Okay, camera is on. My cell phone is off, so we're good.
All right, we're going to try and keep each one to under 10 for easy uploading. And there we go. The following is a presentation brought to you by ATG Trust. When a married couple files joint tax returns but becomes delinquent in paying, which spouse is liable? Tax law savant Rob Wood explains the implications in the Los Angeles Daily Journal in his article, Taxing Innocent Spouses, 10 Things You Should Know. Rob, by the way, is a partner at Wood & Porter in San Francisco, and he's host of the Tax Law Channel here on the Legal Broadcast Network. Hi, Rob.
Hi, nice to be here, Scott.
All right. We've talked before about innocent spouses. Let's explain it again. This is, I guess, probably a good example of this situation would be maybe in some kind of a divorce thing, perhaps, or I guess it even occurs when couples are still married.
Yeah, no, it does. Although, as you say, certainly divorce is the most prevalent example. Even death of a spouse can sometimes trigger these things. But I mean, overarchingly, the issue is most married couples file joint tax returns. I think we are encouraged to do that. I think most of us know that on some level we get a benefit to having income combined. Certainly there's a simplicity. If you're married with a couple of kids, it's a married filing joint return and the kids are claimed as dependents. So it all sort of seems to make sense. I think, interestingly, as I point out in the article, many people these days, including obviously wealthy people, but even people of fairly modest means, at least think about, they don't necessarily do it, but they think about a prenuptial agreement, which obviously is designed to sort of set the stage that if the marriage doesn't work out, at least there's some kind of consideration given to where the assets ought to end up. Surprisingly, though, I think most of us, most married people, do not think about potential tax liabilities and what happens if your spouse or former spouse made a lot of money and didn't tell you, or had a bunch of tax skeletons in the closet. So yeah, it certainly, divorce is probably the most likely circumstance for this type of issue to come up, where one spouse is saying, gosh, I didn't know about that, even though we filed joint tax returns, it's unfair to hold me accountable. But as you say, it can come up during marriage as well.
And as you say in your article, having all the facts helps. Like, well, I wasn't even aware of this, perhaps, in determining a spouse's tax status. But the problem, even if you have all the facts, is convincing the IRS, isn't it?
It is, and the IRS, as you might predict, they've heard sort of every excuse in the book, so it's not surprising that they demand a fairly high standard of proof. I mentioned in the article sort of how you start the process, a particular form that you file, and being specific is important because they do have kind of a checklist of things they look at, and certainly one is, did you know about it? And or even if you didn't know about it, subjectively know about it, that if you benefited economically. So, gosh, you didn't know where all the money was coming from, but you knew that, your kitchen was remodeled and your bathrooms were remodeled, and those kinds of things can obviously help to defeat an innocent spouse claim.
It's not uncommon, too, for lots of spouses to not have really entire knowledge of what's really going on with finances or taxes, and this is a big area where you can get in trouble.
It is, and as you say, it's something that, it's almost a division of labor kind of thing. I think often in a married couple, you have one person, whether it's the husband or wife, who is more equipped to deal with the tax issues, kind of watches the family finances, typically both people are not equally involved in that sort of thing. So whether or not both parties work, and obviously there's working and then there's working. Some things are more complicated than others. If both husband and wife are W-2 wage earners, it's a simpler tax picture typically, regardless of how much or how little they make. It's a simpler tax position to report on a return than it is if one or both are self-employed and have their own business. But yeah, there's nothing wrong with division of labor. There's no rule that says that you have to be aware of everything. But it's always when things start to fall apart that the sort of issues come up, and that's when you may think you had a good handle on what was going on, and if you didn't, it certainly behooves you to look at the innocent spouse rules and see whether you qualify.
A couple of things that you mentioned that seem to be important, even though the IRS is fairly hard to convince. They do consider fairness in some ways, and it's also important to mention the timing is a factor as well.
Yeah, that's right, and basically on timing, fairness. You're absolutely right. If you look at some of the cases, and it's actually fairly easy to do yourself, to go on the internet and or the IRS website actually is. I know I've commented on that before on the tax channel. The IRS website is pretty darn good, and you can find a lot of information there. And if you type in innocent spouse, you'll see some examples of what they think works and what doesn't. And fairness is certainly a big issue. But on timing, Scott, you're right. That's very significant. Generally speaking, you have to make your claim within 2 years of getting an IRS notice, basically IRS collection activity. Sometimes there are disputes about this, about what is notice, and the taxpayer will argue, "Gosh, I didn't figure from this notice that this is what this was about, undisclosed gambling winnings. I had no way of knowing that." And then the IRS obviously, typically would have the other position saying, we gave you notice. You should have figured if both of you were earning wages and each of you made $50,000 a year. When you got an IRS notice saying that you owed $3 million, you should have, for unreported income, that should have told you something major was wrong. So basically, from two years from that date, you have to make your claim. Otherwise, it's too late. You're sort of stuck with the joint liability, even though you may have been sort of quote-unquote innocent.
Rob Wood is a partner in Wood & Porter in San Francisco. You can find him and his articles at woodporter.com. Also here as host of the Tax Law Channel on the Legal Broadcast Network. Again, this is a presentation brought to you by ATG Trust. Rob, thanks for talking with us today.
Thanks. Nice to be here.
This is Scott Drake, and you're watching the Legal Broadcast Network. I like that sound. That's cool.
It's some kind of a call coming in. Okay,